Before this meeting begins, I would like to advise the public of the following. This is a meeting to host public meetings on matters requiring approval under the Planning Act. During the meeting, there will be an opportunity for questions and answers from the committee and the public. Before we begin, members of the public are advised that if a person or public body does not make oral submission at the public meeting or make written submission to the Corporation of the Municipality of Central Elgin before the decision, the person or public body is not entitled to appeal the decision of the Council of the Corporation of the Municipality of Central Elgin to the Local Planning Appeal Tribunal. Further, if a person or public body does not make oral submission at the public meeting or make written submission to the Corporation of the Municipality of Central Elgin before the decision, the person or public body may not be added as a party to the hearing of an appeal before the Local Planning Appeal Tribunal unless, in the opinion of the tribunal, there are reasonable grounds to do so. Those wanting to be notified of Council's decision on any application should email Diane Wilson at dwilson@centralelgin.org, indicating which meeting they wish to be notified on and providing their name and address. Those who do not have access to a computer and wish to be notified should call Diane Wilson at 519-631-4860 extension 286 and provide the same information. We will call this meeting to order. This is a public hearing as required by the Planning Act to hear the applicant Valerie Barendregt. Apologize if I got that wrong. And every other person who desires to be heard in favor of or against the application for a minor variance or permission from the zoning bylaw respecting 43075 and 43105 Roberts Line. Do any members of the committee have a disclosure concerning this application? And I'm seeing none. If the applicant or agent is listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you have called into the meeting using a telephone, please dial *9. We will acknowledge your raised hand and you will be unmuted to explain the application. Mr. Perrin, do you have the applicant? Valerie, would you like to go ahead? You need to unmute yourself. Valerie, you're still muted.
Got it.
Thank you.
Sorry, this is my first time.
Oh, no worries, no worries. You're like the rest of us. I think we've all done it at one point. Could you please explain the reason for your application for us, please?
Yes, I'm applying for this variance because I want to downsize to something smaller that's a little less upkeep and no stairs. I would like everything all on one floor.
I get that. Thank you very much. Nothing else to add, is there?
No, I don't think so.
Okay, thank you very much. Ms. Wilson, in which method of notice and when was notice given to the public of the hearing?
Madam Chair, as per requirements of the Planning Act, notice was mailed by regular post to every owner of land within 60 meters of the subject property on Friday, March the 12th. Notice was physically posted to the property by municipal staff on that day and published to the municipal website. Notice was also displayed in the weekly CE Buzz advertisement.
Thank you. Mr. McClure, do you have any comments with regards to this application?
Nothing further at this time. Thank you.
Thank you. Do any staff have any comments with regards to this application? Seeing none, hearing none. Ms. Wilson, have you received any written submissions on the application?
Madam Chair, no correspondence has been received.
Thank you. Do any members of the committee have any questions or comments with regards to the application? And Councillor Fair, go ahead.
I just had one. You're saying you're downsizing, but it looks as if you're building a bigger house. Am I right in that?
No, No, the house that I'm building is about half the size of the one we're living in right now, that I'm living in right now.
Oh, because there's 195 and the other one you're in now is 100. So,
Yes,
okay.
Councillor Cravitz?
Currently Valerie's living in the other house on the property, which is a larger house.
Oh,
Yeah, it's the other one she's tearing down to build a small ranch.
okay.
Valerie's my neighbor. So thank you.
Okay, I understand it now.
Thank you, Councillor Cravitz. No other questions from the committee? No, thank you. Mr. Perrin, do we have anybody from the public wishing to speak with regards to this application?
Seeing no raised hands. If someone from the public would wish to address this application, you need to raise your hand and we'll acknowledge you. Seeing none, Madam Chair.
Thank you, Mr. Perrin. So everybody has been given a fair opportunity to be heard. Is the committee ready to make a decision? All those in favor? And that application.
You have to call.
Oh,
Karen.
sorry, that's right too. Sorry. Sue, could you please call the vote? I'm really bound and determined to do that myself.
Councillor Cook,
Yes.
Councillor Cravitz,
Yes.
Councillor Fair,
Yes.
Deputy Mayor Marks,
Yes.
Councillor Rowe. Yes. Mayor Martin
Yes.
and Councillor Wynn.
Yes. That application is granted. Those wanting to be notified of the committee's decision on any application should email Diane Wilson at dwilson@centralelgin.org, indicating which public meeting they wish to be notified on and provide their name and address. Those who do not have access to a computer and wish to be notified should call Diane Wilson at 519-631-4860, extension 286, and provide the same information. This meeting is now adjourned.
Thank you, Valerie. She's gone.
Oh, yeah.
Is there a hockey game tonight?
Third, think so.
I would just like to notify the public that the next application has been canceled. So the next hearing will, or the next meeting will commence at 6 p.m.
It's got this.
Yep, wait, yeah.
To call this meeting to order. This is a public hearing as required by the Planning Act to hear the applicant Craigholme Estates and every other person who desires to be heard in favor of or against the application for a minor variance or permission from the zoning bylaw respecting 178 Kettle Creek Drive. Do any members of the committee have a disclosure of interest concerning this application? None. If the applicant or agent is listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you have called in to the meeting using a telephone, please dial *9. We will acknowledge your raised hand and you will be unmuted to explain the application. Barbara, I see your hand raised. If you would like to go ahead, please, and explain the reason for the application.
Thank you, Chair. Yes, my name is Barbara Rosser, and I am the planning consultant for Craigholme Estates and the agent for this application. The application proposes variance to the exterior side yard setback to 3.5 meters from 4.5 meters, and to permit a covered or uncovered, unenclosed deck to project into the required rear yard beyond the permitted encroachment of 1.5 meters. When I was preparing for the meeting this afternoon, I noticed that there was an error in the application. The committee will note that the staff report references that the deck that would be proposed would project a maximum of 6 meters into the required rear yard. That is based on an error in the drafting of the application. The site plan that was submitted indicated that the deck would encroach 4.5 meters into the rear yard and not 6 meters. So the extent of the variance is not as great as what was the staff report was predicated on. Regardless, this is a matter that with regard to the exterior side yard variance that's being sought, it is an issue that was addressed by way of prior variance for 4 lots in phase 4 of Belmont Estates, where the exterior side yard setback was reduced by 1 meter to 3.5 meters from 4.5 meters. And that is simply to give builders more flexibility on the house designs that were that would be feasible on one of the corner lots. And the exterior side yard only applies to corner lots. So we are seeking the same kind of accommodation for this lot, which is also a corner lot, and also a variance for the encroachment for an uncovered deck. We have taken note that there have been, I believe, 4 prior deck variances in Belmont Estates related to the rear yard encroachment, which currently is only permitted to be a maximum of 1.5 meters, which doesn't address deck requirements these days in residential development. So we are suggesting 4.5 meters, so 3 meters beyond the 1.5 meters, and that would still leave a 6 meter rear yard setback from the deck. In all other ways, the proposal would meet the building envelope of the Belmont bylaw as it applies to the R1 zone.
Thank you, Barbara. Ms. Wilson, what method of notice and when was notice given to the public of the hearing?
Madam Chair, as per requirements of the Planning Act, notice was mailed by regular post to every owner of land within 60 meters of the subject property on Friday, March the 12th. Notice was physically posted to the property by municipal staff on that day and published to the municipal website. Notice was also displayed in the weekly as advertisements. Thank you.
Mr. McClure, do you have any comments with regards to this application?
Thank you, Madam Chair. Nothing further than what was in the report and the clarifications that were provided by Ms. Rosser in her presentation.
Thank you. Are there any comments from municipal staff? Hearing none. Ms. Wilson, have you received any written submissions with regards to the application?
Madam Chair, no correspondence has been received.
Thank you. Do any members of the committee have any questions on the application? Seeing none. This meeting will now be open to questions from the public. If you are listening on your computer, tablet, or smartphone, please click the raised hand icon. If you have called into the meeting using a telephone, please dial *9. The questions will be taken in a sequential order. When given the opportunity to speak, please provide your name and address for the record. Mr. Perrin, do we have anybody waiting to speak?
Go ahead, Mr. or Mrs. Craigsman.
Hi there, thanks, Lloyd. First question I have is there a specific plan for a structure on that property?
I'm sorry, could you please repeat the question? I had a hard time hearing it. So if you could repeat again, please, in case someone else did.
Sure. Is there a specific plan for a specific structure, I should say, planned for that property?
Barbara, would you like to speak to that, or Mr. McClure?
Thank you, Madam Chair. I believe it'd probably be best to speak to the applicant about what their intentions are for the property.
Thank you, Barbara. Would you like to speak to answer the question?
Yes, thank you, Chair. A single detached dwelling is the development that is proposed for the lot. I did provide a site plan that accompanied the application. I'm not sure whether Mr. McClure can provide that or not, but it indicates a single detached dwelling that would meet all of the front yard setback, the interior side yard setback, the 3.5 meter exterior side yard setback, and then it depicts the proposed deck at 4.5 meters into the rear yard.
Thank you. Does that satisfy your question, Alex?
Thanks for that. I guess I'd like a little more specifics. I understand that it's a single family residential dwelling that's going to go on that piece of property, but are you able to be more specific? Is this a 1-story, a 2-story, a back split, or has that been sorted out yet?
Go ahead,
Chair,
Barbara.
Chair, I can clarify that the lot has yet to be sold. It's still in the ownership of Craigholme Estates.
Okay.
So that matter has yet to be determined.
Okay, thank you. Yeah, so Alex, there's no idea at this moment what type of home will be on there. Did you have another question or concern?
I'm good for the moment. I'll have some comments later if you'll allow me to do that.
Well, this is your opportunity now. We'll be making a decision on it next. So if you have
I
more.
understand that. I understand that. I think there
You
are
mean
more.
at a later date? You would at a later date,
no.
or now you would like to?
No. I'll stand back here. I think there are other neighbors who probably will have some questions or comments to make, and then I'll finish mine.
Okay. Okay. Mr. Perrin, do we have anybody else wishing to speak?
I see no other raised hands. If anyone would like to speak, oh, there's one.
Okay. Larissa?
Hi, yes. My name is Larissa Chapman. You need my address?
Yes, please.
I'm at 203 Kettle Creek Drive.
Thank you. Go ahead.
My family was involved in a car accident that was as a result of a motorist coming around the corner that the house we're talking about is on. The motorist wasn't able to make the turn and came over my property and damaged 3 of our cars on our property. No one was injured, but this incident there was a police report and everything about it. So already our neighborhood is quite concerned about this corner. And I would hope that it would be raised today as well, that this is where the entrance to the local neighborhood park is. So there is a lot of foot traffic as well. So any variance on a house or deck that would jut out and impede vision for children or families walking here, or for those of us on the side of the street where the corner bends, where we've already had an accident in this area. I hope that you would consider that when you're making your decision.
I can ask staff on that now. I am very aware of the accident in question, and I know there were quite a few other circumstances that arose for that to happen. But I can ask staff now, or Barbara, if they could speak to that. I'm sure there's something in place for building that ensures there is no obstruction to sight lines for traffic. Or
Well,
at some point, there's a consideration for that?
You're quite right, Chair, that the zoning bylaw does have site visibility standards with regard to intersections. And the plan of development for this property would have to meet those requirements. And I just point out that the plan that was submitted along with the variance application indicated that the proposal was based on meeting the required front yard setback of 6 meters. And that applies everywhere within the R1 zone. And there has been no indication of any concern from staff with regard to the 3.5 meters not being adequate. In fact, 4.5 meters is certainly considered to be excessive when it comes to exterior side setbacks, which often are even less than 3.5 meters. So
Okay.
I'm just Chair.
Thank you, Barbara. Yes.
Madam Chair, I believe the Larissa is talking about the next application, the Ramona Lane one. We're dealing with the other one first.
Oh, Larissa, you are taking into consideration the Ramona Lane, are you not?
I am talking about the Ramona, yes.
Yes, sorry, we're actually on the other end of the subdivision right now with the current property that we're talking about. Your application is coming up next.
Thank you.
Okay, thank you. So stay on. If there's anything further that can be added to this, or if you have another question with regards to that application, but we'll finish up this one for Kettle Creek first, and then we'll be on to the Ramona Lane. Okay. Mr. Perrin, is there anybody else in the waiting room?
One second, Madam Chair.
Okay, thank you.
Go ahead, Mr. Craigsman.
Alex, go ahead. Alex, are you there?
Yes, I am now. We had a momentary interruption of service, I guess.
No problem. Go ahead.
I just wanted to then clarify. I listened to the exchange that you had with Larissa. I know that there are 2 applications here in Belmont. I just want to clarify. The application that we're talking about right now, is this the application for the variance at the corner of Kettle Creek Drive and Ramona Lane?
No. This is the other, no, this is the other end of that block that we're dealing with right now. If you are looking at the one at the corner of Kettle Creek, the continuation of Kettle Creek
Yeah,
and Ramona Lane, that's
Yeah.
the next application.
okay. Yeah, we received the wrong notice then.
Okay, well, and again, that application is coming up next. If you would like to
Yeah.
stay on,
Yeah, we will.
we can finish your conversation with that application.
Okay, very good. We'll wait.
Okay, thank you. Mr. Perrin, is there anybody else wishing to speak?
No one else, Madam Chair.
Okay, thank you. Everyone has been given a fair opportunity to be heard. Is the committee ready to make a decision? Yes. Ms. Wilson, could you please take the vote?
Councillor Cook,
Yes.
Councillor Krebitz,
Yes.
Councillor Fair,
Yes.
Deputy Mayor Marks,
Yes.
Councillor Rowe,
Yes.
Mayor Martin,
Yes.
Councillor Wynn.
Yes. That application has been granted. Those wanting to be notified of the committee's decision on any application should email Diane Wilson at dwilson@centralelgin.org, indicating which public meeting they wish to be notified on and provide their name and address. Those who do not have access to a computer and wish to be notified should call Diane Wilson at 519-631-4860, extension 286, and provide the same information. This meeting is now adjourned. And we'll go directly into the next. Call this meeting to order. This is a public hearing as required by the Planning Act to hear the applicant Craigholme Estates and every other person who desires to be heard in favor of or against the application for a minor variance permit or permission from the zoning bylaw respecting 126 Ramona Lane. Do any members of the committee have a disclosure of interest concerning this application? And I'm seeing none. Barbara, would you like to explain the reason for the next application, please?
Thank you, Chair. This application is very similar to the prior application in that the reason for the application is to permit an encroachment into the rear yard for the purposes of a deck, an uncovered deck, beyond what the permitted encroachment in the bylaw of 1.5 meters. And the variance is based on 4.5 meters, not 6 meters, again, due to a similar drafting error. So 4.5 meters is what is being sought by the variance application. And also a reduction of 1 meter in the minimum exterior side yard setback of 3.5 to 3.5 meters, as opposed to 4.5 meters. In this case, just by way of explanation, it was determined by through consultation with staff that the front yard for a proposed dwelling on this lot would be on the north side, and the rear yard would be the south side. So the permitted deck encroachment would be on the south side of a dwelling unit. And of course, the exterior side yard is on the east side. In all other respects, a dwelling proposal would meet the setbacks of the bylaw, those being front yard of 6 meters and then the interior side yard setback. So we did provide a site plan drawing to depict the two variance proposals, and the basis for requesting the variances is similar to the prior one, in that the extra meter of side yard would provide more latitude for the builders in determining a house plan for this lot. And as well, again, as evidenced by prior variances within Craigholme, decks quite commonly do exceed 1.5 meters in terms of encroachment into a rear yard. And so the variance that we're seeking is fairly consistent with what the 4 prior variances that you granted in that respect.
Thank you, Barbara. Ms. Wilson, what method of notice and when was notice given to the public of the hearing?
Madam Chair, as per requirements of the Planning Act, notice was mailed by regular post to every owner of land within 60 meters of the subject property on Friday, March the 12th. Notice was physically posted to the property by municipal staff on that day and published to the municipal website. Notice was also displayed in the weekly CBuzz advertisements.
Thank you. Mr. McClure, do you have any comments to add with regards to this application?
Nothing further. Thank you.
Thank you. Are there any comments from municipal staff? Seeing none. Ms. Wilson, have you received any written submissions on this application?
Madam Chair, no correspondence has been received.
Thank you. Do any members of the committee have any questions or concerns with regards? Mayor Martin?
What I would be appreciative, maybe if Mr. McClure in the future could give us the site plan, like it's not included in our thing, so we can't see exactly where this is supposed to be and where the setbacks are. I'm glad at least Ms. Rossiter told us which was the front and the side and the back. But it would really help if we could see those.
Okay, that's a discussion I guess we could have at another time with regards to that, Mr. McClure. Just lost my place, my apologies. Okay, do any members of the public have any questions on the application? And Mr. Perrin, I'm just going to ask if we've had anybody new come in to the waiting room with regards to this application?
There are new attendees. If anyone has a concern about the application, please raise your hand.
I'll just note that if you are listening on your computer, tablet, or smartphone, please click the raise hand icon, or if you've called into the meeting using a telephone, please dial *9. Questions will be taken in a sequential order. When given the opportunity to speak, please provide your name and address for the record. We don't have anybody new putting their hand up.
No, Madam Chair.
Alex, would you like to continue with your questions that you had previously? You need to unmute. Alex, if you'd like to unmute yourself, you can go ahead.
There, can you hear me now?
Yes, we can.
Okay, great, thanks. Thanks for clarifying which application this was. We received notice for the other one at the far corner, and so this makes more sense to us.
Okay,
First,
no problem. Go ahead.
Yeah, first of all, let me say I have no axe to grind with Craigholme Estates or Mr. Snyder. In fact, quite the opposite. I just wanted to make a few things known here about this corner. All the occupants here, all the residents, first of all, we live directly east of the subject's lot that you're talking about, just across Kettle Creek Drive at 201 Kettle Creek. So we face the lot that's open. All of the people that are directly sort of connected to that lot have been long-term residents here or second-generation families. We've been here 18 years, and I think other than the second-generation family, we're the newest people. People come to Belmont because they value the openness and the community feel of a small open village with room for kids and families. And I realize that this is just a variance on a lot, but the congestion, the potential congestion concerns me in this corner. Larissa spoke about it earlier, about the fact that families come and go past this very corner to take the path to the park. They come down Kettle Creek Drive, they come down Ramona Lane. This is a a crossroads for families on foot, with kids on bicycles. And congestion concerns me at this corner. Having been a long-term resident here, me and my family have seen it time and time again, the number of pedestrians and cyclists that come by here. Second of all, Larissa raised the subject of the collision that happened in the fall of 2018. And in my view, the lot that's directly, that what we're talking about here should never have existed in its current form. And I'll tell you why. The street, the way it was developed, is not a sweeping curve to allow traffic to make the corner into the back new development. It is two 45-degree angles on a narrow street. There is no traffic control. There are no stop signs. There are no yield signs. There are no reduced speed limit signs, and there are no speed bumps. I can tell you, living at this spot, seeing the traffic that comes and goes here, there is no control. And it's concerning to all of us. It's concerning for a number of reasons, not the least of which are all the kids in this corner. The fact, I get it, there are extenuating circumstances surrounding the collision that happened in 2018. I know that. I was there that night, and you know, I'm a police officer. I understand, you know, some of the extenuating circumstances, but I also understand via my work, but also being a resident here, what is going on in front of us. That collision, I fear, is going to be the first of many. And thankfully, Larissa said it, nobody was hurt that night. It happened to occur late in the evening when there was nobody out. Thank goodness for that. But put those extenuating circumstances aside, the way this corner is built is a disaster waiting to happen with all of the kids that come by here. On top of that, speaking selfishly, I acknowledge that street turns right up our driveway and looks right in our front window. The night that collision occurred, could have easily come through our front window. Thankfully it didn't. It came up over the yards, struck a tree, and destroyed 3 cars, including one in Larissa's driveway near her home. The congestion, I believe, is unreasonable. The way this was laid out in the first place is unreasonable. And I think that to allow this variance just contributes to the congestion. I do believe that the street was designed in a manner to maximize the space, the attractiveness, and the value of the lots that line the ravine. I understand that. The developers there, it's a business. I get that. The downfall of the whole thing is the way the street was designed and built. It is an accident waiting to happen. Thankfully, nobody was hurt that night. It was carnage out there, unfortunately. So I'm asking you to consider that when you make your decision. Congestion is not the answer here, but congestion is what you're going to get. Thank you.
Thank you. Is there staff or Barbara, if you wanted to speak to that as to how the street was developed, created, what goes into it, and how the issues that Alex raised are taken into consideration?
Well, Chair, in that respect, and I'm sure staff may want to add something to the comments I'm about to make, but in its consideration of a draft plan of subdivision proposal, the municipality requires a number of plans and studies to support the draft plan. Among them are things like traffic impact, and as well as a variety of other studies, of course. and the county is the ultimate approver. Although at the time that this particular plan was approved, I think it was the province of Ontario was still doing the municipal approvals. But these matters are vetted quite in a lot of detail and quite extensively prior to approval. And so, you know, certainly the county weighs in, the municipality weighs in, and the developer is obliged to respond to any concerns that are raised and to ensure that the matters are the typical matters relating to a subdivision, including layout and street pattern, are appropriately designed. And so that's just the comment I would make with regard to the background for this particular lot. It, you know, I really can't speak to the accident and what conditions contributed to it. But as the subdivision builds out, there are periodically times when municipalities do want to implement the kinds of things that this gentleman referred to, like reduced speed or speed bumps or stop signs or that sort of thing. Quite frankly, I haven't really seen the connection between reducing the 1 meter exterior side yard and any potential for congestion or you know, those sorts of things. Quite often the side yard, and I'm sure Mr. Perrin can verify this, the main concern is whether there's adequate area for snow storage when the streets are being plowed. But that has certainly been borne out as not a concern in this instance or in the instances of the prior corner lot exterior side yard variances that were granted. It and I have to say that 3.5 meters is still on the large side when it comes to exterior side yard setbacks. So at this time, I don't think there's anything else that I can add to that. Mr. Snyder's is present, and I'm sure if he has comments, he'll be raising his hand. But at this time, that's the extent of what I can offer.
Thank you, Barbara. Is there staff who could speak to the concerns with regards to traffic and any additions that could be added to the area to help ease concerns, or what requirements would need to be met in order for stop signs or any type of traffic calming would need to be looked at for that particular area? Mr. Brooks, welcome.
Thank you. So we'd be happy to review the area. What I can tell you is that we have reduced the speed limit on Kettle Creek Drive and the remainder of the subdivision to 40 kilometers per hour. And there was a number of concerns that were brought forward last summer in regards to speeding on Kettle Creek, and we found that the rate of speed on Kettle Creek didn't warrant any traffic calming devices. However, with the concerns we've heard here, we can take another look at that particular corner and see if there are any other warrants that may bring on some kind of a change to the traffic patterns there, or addition of stop signs and that sort of thing. I would say that in the OTM books from MTO that stop signs are not to be used as speed reducing devices. But that being said, we'll certainly take a look at that corner. Off the top of my head, I can't tell you if there are any warrants specifically that would change the current setup of that curve on Kettle Creek Drive.
Okay, thank you, Mr. Brooks. Was there any other staff member who had anything else to add with regards to that concern? I'm seeing none. Larissa, I'm just going to ask if you had anything further.
Hi, I think my concerns have been at least raised for now. Thank you.
Okay, thank you. Alex, is there anything further that you would like to add, or anything from what Barbara or Jeff Brooks had to add? No, Alex, nothing further?
Can you hear me now?
Yes, we can.
Okay, yeah, okay, thank you. First of all, I heard what Ms. Rosser said about the, studies and whatnot. And I get that. It's admirable that all of these studies have been done. I'm telling you that the experience on the ground is what it is. And it is scary at times here when vehicles round that corner. I also heard what Mr. Brooks said about reducing the speed on Kettle Creek Drive. We appreciate that too. It's a residential neighborhood. But that 40 kilometers an hour along Kettle Creek Drive on a straightaway is significantly different than 40 kilometers an hour on two 45-degree angles, including a 45-degree angle that points directly at our house and at Larissa's house, which already has resulted in a significant collision. I also understand what Mrs. Prosser said about she's, not entirely sure how that sort of my concerns relate to the application for the variance on the setback. I understand your position too, Ms. Rosser. My point is the safety, first of all, of the neighborhood, and second of all is the amount of congestion that's will result by just changing the rules here. Like I said earlier, that lot in its present form and shape and size should never have existed because this corner here is poorly designed and should have been more sweeping or on a 90-degree angle with a turn and a stop sign. It is what it is. It's been done. The lots have been sold and they're starting to develop. Now I'm asking you to put a stop to bending the rules and taking this further and preserve a bit of the space and the safety of this corner because it's an accident waiting to happen. In fact, it already has.
Thank you, Alex, for that. As Mr. Brooks had mentioned, that they will have a look, come out and look at that corner again. I can say, and staff can jump in, when the subdivision is planned, it wasn't planned for the original amount of homes that you see there now, or even previous to the last couple of years. It is planned out for all the phases. So when traffic studies were done and when these streets were developed, they were developed with having that subdivision fully completed, not developed up to your point, what you see now. They've already looked into the future, taken into the account how many homes would be in there, the amount of traffic those homes would produce, and those roads are developed to that. If staff can, am I correct in that assumption? Mr. McClure?
Yes, thank you, Madam Chair. Yes, at the time of the original subdivision, all of that information would have been provided and the recommendations and decision by council would have been made based on those recommendations. So the traffic would have been looked at. Just with respect to the zoning itself, the setback is for the building and structure itself. There are specific setback, well, I guess there are specific provisions in the zoning bylaw as well that would speak to sight lines in that. So if there were ever to be I guess a fence along the property line, they would still need to respect the sight lines as well through the zoning. So while I guess what they're requesting is for a reduction in side yard setbacks for the buildings and structures, there are certain provisions in the bylaw that would still look at sight lines from the property lines as well. So, but yes, from a traffic standpoint, to original question, that would have been looked at the time of the draft plan of subdivision and its ultimate build out.
Thank you. And those sight lines, all of that will be taken into consideration when an actual plan for a house comes forward. And that all has to be met before permits are given. Correct?
Yes. So the property and the siting of the building, if it meets the requirements of the zone, which would take into consideration the sightlines aspects at intersections, that would be covered all at the time of the building permit.
Okay, thank you, Mr. McClure. So is there anything new that either of Larissa or Alex would like to bring forward? I think we've covered the traffic. If you have a new concern that you would like to bring forward.
Madam Chair, I have Joe Snyder with his hand up.
Oh, okay. Mr. Snyder, welcome. You need to unmute, Joe.
I think I got it.
Thanks, we can hear you now.
Thanks all. Thank worship. Mayor, I just want to answer my response to Alec. I know Alec well.
Go ahead.
Oh, I'm still talking. I'm just thinking. I'm a little slow. I'm not a counselor, so I don't know everything.
No, we know you would like to take your time. Make sure you say it right. Go ahead.
So anyway, Alec is right on his response. But that accident that happened in this corner has nothing to do with what's going on with this subdivision. There was and I don't want to mention any names, some kid got drunk and there was an accident on his corner a couple of years ago. It has nothing to do with traffic patterns. So please don't go there. You guys can decide what the hell you want. That has nothing to do with this minor variance on side lots. His comments are out to lunch. Okay, I'm done.
Thank you, Joe.
Thank you.
Okay, I ask again if there are any new concerns or questions with regards, and Mr. Kravitz, or sorry, Councillor Kravitz, go ahead.
Now, my question is towards Barb or possibly Joe. The side yard setback that you require, the 3.5 meters, that's on the east side of the building. There's no way that's ever going to restrict the view coming around the corner of that Kettle Creek. That would be my only concern with that side yard setback that you're asking. The bylaw states you're allowed to have a 4.5. Is it the end of the world if you don't have the 3.5? I see the rear yard setback does make sense for the deck, but my question is about your side yard relief that you're asking for. Is that 1 meter going to kill this lot? Thank you.
Joe?
Chair, Joe may want to weigh in on this, but I would just, the comment that I would make is that in the case of the 4 previous instances for corner lots in phase 4, where Craigholme obtained the exterior side yard variances, those were based on input from the builders, that there was a desire for more flexibility in terms of house plan, and that meter was helpful in terms of accommodating more buyer preference. I guess that's the best way to put it, or more lot owner preference. Joe may be able to speak to it better than I, but I would reiterate what Mr. McClure had to say, in that when a building permit application is submitted, the application does have to meet all applicable regulations of the zoning bylaw, including sightlines. So if the site plan that we provided in some way does not meet all requirements of the bylaw, then it would have to be changed in order to have a permit be issued. But in other respects, we can meet the bylaw. So I'm not sure if Joe can weigh in based on his experience dealing directly with the builders or not.
Joe, would you like to add? You need to unmute. You're still muted. Then I'm going to assume you didn't have anything else to add. I'm going to call for a last request of any new questions or concerns with regard to this application.
Madam Chair, Mr. Craigsman has his hand up again.
Mr. Craigsley, Alex, go ahead.
Can you hear me okay?
Yes, we can.
Okay, first of all, we over here love Joe, so I'm not offended by his comments that my comments are out to lunch. I'm good with that, Joe. Our concerns have to do with the congestion, like I said, at this corner here. And I hear what you're saying about the setbacks. It's the idea that, you know, we're looking at bending the rules again here for this corner to accommodate this. And my concern has to do with neighborhood safety and the congestion that has to go on, that goes on here. And you know, he gave some details about the collision that happened. I can tell you that living here and seeing this daily, the traffic that comes around the corner, drunk or not, it's a collision waiting to happen.
Okay, thank you. And as staff had stated, they're going to take another look at it as well too. And any plans for a home build are going to require another look at it as well. If there's no new questions or concerns, last call, Mr. Perrin.
Madam Chair, Mr. Snyder still has his hand up. I'm not sure if he wants to try to address the committee again.
Last call, Joe, if you did have something that you wanted to address, it's just you're muted, so we can't hear you. Which is making me talk louder. I'm going to take that we've heard all questions and concerns. Is the committee ready to make a decision? Yes?
Yes.
Ms. Wilson, if you could please take the vote.
Counselor Cook,
Yes.
Counselor Cravitz,
Yes.
Counselor Fair,
Yes.
Deputy Mayor Marks,
Yes.
Counselor Rowe,
Yes.
Mayor Martin,
Yes.
Counselor Wynn.
Yes. That application is granted. Those wanting to be notified of the committee's decision on any application should email Diane Wilson at dwilson@centralelgin.org, indicating which public meeting they wish to be notified on and provide their name and address. Those who do not have access to a computer and wish to be notified should call Diane Wilson at 519-631-4860, extension 286, and provide the same information. This meeting is now adjourned.
There you go.
As in
Hey.
live.
Good evening, everyone. I'm Tom Marks. I'm going to chair the meeting for the Court of Revision tonight. Welcome. We're a bit late. I apologize for that. The public hearing as required by the Drainage Act to hear appeals as to assessment relative to the following drainage project, being the Grauberg Drain. Do any member of the Court of Revision have a disclosure of pecuniary interest relative to this matter? Noting none, I'll now introduce Mr. Jeff Brooks, who's our Director of Infrastructure and Community Services, to provide a brief overview of the process with respect to the Court of Revision. Jeff, go ahead, please. Are you with us, Jeff?
Sorry about that. I just had to take a short little break.
Go ahead. You're up to explain the Court of Revision.
Okay, my apologies, Mr. Chair. So we're here for the Court of Revision. Council previously considered and accepted the drain report at a prior meeting. The Court of Revision is being held to provide landowners the opportunity to appeal land assessed for drainage work in regards to the following three issues. Number one, any land or road that has been assessed too high or too low. Two, any land or road that should have been assessed has not been assessed. And number three, that due consideration has not been given to the type of land use. It should be stated that if the court wishes to adjust an assessment up or down to one individual landowner, the court will have to add or subtract that change in assessment from other assessed landowners as the cost of the drain, does not change. So anyway, I'll turn it back to you, Mr. Chair.
Thank you, Jeff. I'll now ask our Deputy Clerk, what appeals have been received relative to this proposed drainage project, please?
Mr. Chair, no appeals have been received for the Grauberg Drain.
Thank you. Glad to hear that. We have Brandon Widner from Spreed Associates here. Do you want to go ahead and give the basis for the determination of the assessment, Brandon? Welcome.
Good evening, everybody. Tonight we have the Grauberg Drain. This is a drain located near 74 and Ferguson line. It's mainly in the lands of the Thompsons. In the report, you can see on page 11 and 12, the assessments are broken down. Total cost of the project is about $225,000. You can see there's a couple special assessments to the County of Elgin. Those are for the borings under Ferguson line, but the rest of the assessments are noted. This is drains made up of a main drain, a branch number 2, and a branch number 3. But I haven't heard any feedback from the owners. I know they're I would say awaiting construction. They're anxiously awaiting for construction this fall. So I've heard nothing from them or any complaints regarding any of the assessments.
All right, Brandon, thank you for that. Do I go ahead and ask the appellants, even if they aren't, if there is anyone who believes that their land is improperly assessed, and if you're listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you've called into the meeting using a telephone, please dial *9. The questions will be taken in a sequential order. When given the opportunity to speak, please provide your name and address for the record. I would ask Mr. Perrin if there is anyone there.
Seeing no hands.
All right, we'll take that as a good sign. And I should ask engineer, there's no rebuttal, there was no problem there. Have we had any late appeals? I'm hearing none. Do members of the Court of Revision or any members of the public have any further questions or comments before the Court of Revision members deliberate the appeals? Noting none. In my opinion, everyone has been given a fair opportunity to express his or her views regarding this matter. If you wish to receive notice of the decision respecting the Grauberg drain, please email the Secretary Treasurer, Diane Wilson, Deputy Clerk at dwilson@centralalgon.org. Call her at 519-631-4860, extension 286, and provide your name and mailing address. Are we ready to make a decision? I guess we can go ahead and call the vote. Please.
Would you like to hear the draft resolution?
Please,
Okay,
please.
Resolution reads, the Court of Revision agrees to uphold the assessment scheduled for the Grauberg drain as per the report prepared by Brandon Widner, engineer, Spreet Associates, and further that if dissatisfied with the decision of the Court of Revision, which was pronounced on the 22nd day of March 2021, anyone may appeal this decision to the Agriculture, Food and Rural Tribunals by filing a notice of appeal with the clerk of the municipality within 21 days of the date of this decision.
I'll move that.
Moore,
Second.
Moved by Councillor Kravitz, second by Councillor Wynn. Please call the vote.
Councillor Cook,
Yes.
Councillor Kravitz.
Yes.
Councillor Fair,
Yes.
Councillor Wynn,
Yes.
Deputy Mayor Marks.
Yes.
Motion carries.
And that, this meeting is adjourned. Diane, on this sheet, phone number is wrong. Is that? Everyone ready? Good evening. I'm Tom Marks. I've been asked to chair the Court of Revision tonight. This is a public hearing as required by the Drainage Act to hear appeals as to assessment relative to the following proposed drainage project, being the Dell Drain Outlet. I'd ask if any members of the Court of Revision have a disclosure of pecuniary interest relative to this matter. And I note none. This time I'd like to introduce our Director of Infrastructure and Community Services, Jeff Brooks, to give a brief overview, please.
Thank you, Mr. Chair. As previously stated, this is the Court of Revision for the Dell Drain Outlet. At a prior meeting, Council considered and accepted the drainage report. The Court of Revision here is being held to provide landowners the opportunity to appeal land assessed for drainage in regards to the following three issues. Number one, any land or road that has been assessed too high or too low. Number two, that any land or road that should have been assessed has not been assessed. And number three, that due consideration has not been given to the type of land use. It should be stated that if the court wishes to adjust an assessment up or down for one individual landowner, the court will have to add or subtract that from another assessed owner as the cost for the drain doesn't change. So I will turn it back to you, Mr. Chair.
Thank you, Mr. Brooks. I'd ask our Deputy Clerk, what appeals have been received relative to this proposed drainage project, please?
Mr. Chair, correspondence has been received from the following: Walter Hayhoe, Roger Somerville, Nelson Parker, Helmer, Jeff Ferguson, Gary Somerville, and Phil McNamee, all of which has been provided to the Court of Revision members, the consultants, and municipal staff.
Thank you for that. I would now like to introduce Mark Hernandez from Dillon Consulting to provide evidence on appeals, which have been received and the basis for the determination of the assessment. Welcome, Mark.
Thank you very much. I can go through the paper appeals or the appeals received in writing if you wish, or if we want to hear from the residents and answer them in turn, we can do that too. Please let me know how you'd like to proceed.
Well, we probably should do the written ones, or, yeah, let's go down the list of written ones, if you would, Mark, please.
Certainly. Just ask for one moment and I will pull those up. So there is a theme amongst the group, so I will try to answer them a bit collectively. There are, like I said, there are a lot of consistent themes, and there's 4 points that I would like to make to respond, and then perhaps maybe we could hear from the landowners. You know, the first common theme in all of the written submissions is that the works proposed are of no benefit to the landowners. And I guess the perspective is that, you know, it isn't changing the level of service for the landowners upstream, but what it is doing, it is controlling the water that is generated from those upstream properties to result in less erosion to Mr. Miller's property. And what has taken place is that the water has been going through Mr. Miller's property for quite some time, decades in fact, and has been causing quite a bit of an erosion. You know, and there's been no costs for the upstream landowners. There could have been. I think we spoke at the last meeting, at the meeting to consider, about how when the works were done in 1997, the works that were proposed could have been taken further downstream to prevent this. I mean, that of course is with the benefit of hindsight, but it didn't, and so those costs were not realized at that time. So now it is coming to bear based on the concerns that Mr. Miller has with respect to his property, how the effect of the erosion is causing the loss of the property, and ultimately really how it affects his residents and his concern with respect to his property there. So that was my first point. The second point that I wanted to make in conjunction with that is I think it's important to note that all of the water flowing through the Dell drain is from upstream landowners. So while the water flows through Mr. Miller's property, none of the water that is flowing through the Dell drain is being generated from Mr. Miller's property. The third point I wanted to make was with respect to some of the work that the municipality had done as this report was being developed in terms of speaking with an appraiser and real estate agent, and while alternate solutions were being reviewed. And what was noted from the appraiser is that the proposed works here are not increasing the value to the property. It is simply maintaining the value. So if there were a situation where, for example, completing these works, you know, increased the value of the property by a given amount, the benefit assessment would have to increase by that amount as well. But in this case, the feedback we've gotten is that it is not increasing the value. It is simply maintaining what the landowner currently has. The fourth point, I guess the last point I'd like to make before kind of closing my opening statement here is that I have reviewed the proposed assessment from the perspective of consistency with what has been established in the past. There were some comments and appeals about the branch drain and you know, previous assessments through that process. However, it is really previous assessments through the main drain that, you know, we would look at, you know, with respect to consistency. And I have done that. When we look back at the assessment that was done, and this is for the works that were across the road back in '97, the landowner at that time of that property, his assessment represented 7.6% of the overall cost of the work. What's being proposed in the current draft report is 6.6%. So it's very, very close. It's not off by a significant amount. And just to put that, you know, in perspective, the current proposed assessment to the landowner is, you know, the landowner who this is on his property is $25,000. If we were to adjust it to be exactly the same as what was established back in 1997, his assessment would only increase to $28,700, so a difference of about $3,700. So you can see that it's really not a significant amount. So I guess I'll close with that, and I'll take any further questions. Hopefully that was helpful.
I think, Mark, we were looking for you to give them, we've had several appeals.
You, Mr. Chair. Mr. Hernandez dealt with the general themes within all those correspondence through his 4 statements. So I think at this point you could open it up to the floor.
All right, then we will move on. At this point, I'm going to ask the appellants to present their case as to why they believe that their land was improperly assessed. If you are listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you've called into the meeting using a telephone, please dial *9. The questions will be taken in a sequential order. When given the opportunity to speak, please provide your name and address for the record. Mr. Perrin, you have the first one, please.
I see no hands raised. Go ahead, Mr. Ferguson.
Thank you, Mr. Chair, Mr. Perrin. So in our sort of assessment or submission to the works and the proposed works here, going over our step-by-steps of our submission is in 2016, branch G of the Dell drain was extended along the road. I can't even tell you the road name. Dexter line. The municipality paid 51% of that project. Meeting with Mr. Miller at the site over times after that, he was concerned with the additional water that put on the Dell drain and on his property. So at that time, he asked for this this municipal assessment to be looked at and to evaluated what was going on. I think that was shortly after the works in 16. If we go on after that, then Dylan was consulted to do work and do some looking at this drain. We met with them. They proposed the work. And the very unfortunate part for, I think, Mr. Miller, all people involved here, was that Dylan told us at that very first meeting, I think in their submission, it talks about their billing or their needs are 100 or 110 grand. I don't know. I haven't really studied it too closely. I think they told us that day at the side of the road, their assessment, their works were pretty much already done, and we were now at $90,000 that their costs were already in. So it seemed like, I think the landowners, that our first real site meeting, when we were told that Dylan, and Mr. Miller as well, that Dylan's costs at this point were $90,000, I think has made this project somewhat divisive. It's created some problems. So as we proposed in here, we don't propose Mr. Miller, but we propose between Central Elgin. So in the last comment that we have, and we've been part of a lot of drains around the countryside over the years, and for the benefit factor to stop at 10%, if you look at it, and we need to pull out 10 or 20 because we've been part of a lot of municipal drains, those benefits factors can run from 35 to 50%. So we set back in that we think the benefit factor is 51%, that should be looked at between Central Elgin and Mr. Miller. I don't know what the split needs to be. We did not spell that out. But I think if we were to bring in other sources of information to say that the benefit factor here on this drain is 10%, I think is low, or it's not even that because we just heard it was 7.6. So that's low. And I think the central Algon contribution for roads is very low too. And we've got put in a bad spot as landowners to tell when we were already informed that it was $90,000 to $100,000. I think the other part that would be really interesting is to go back to 97, see what the original proposal looks like. Here's some people that their memories are starting to go, but they wonder if at the time it wasn't proposed to take the drain farther than it presently is at or stopped. But because costing or the township thought at the time or the municipality thought at the time it was far enough and to reduce costs for people involved and some landowners that we not proceed or go as far. So if it was proposed to go farther the last time, we didn't do that, then that's where I think that we gotta take more of the onus on Central Algon and Mr. Miller, however, but this benefit of 10% is wrong. And council needs to think about that. That's all the comments I have, Mr. Chair.
Mr. Hernandez, would you like to reply to that?
Certainly, I have a couple points. The first point that I would like to make is that the initial site meeting was held and it is minuted in the as an attachment to the draft report, which has been submitted. The initial site meeting was March 10th of 2016. In addition, there was a subsequent meeting. That one was with the general public. All the landowners were invited to that one. There was a subsequent meeting, which is also in the meeting minutes attached to the report, where scale of costs were discussed, not necessarily engineering, but scale of costs related to the work were discussed very early on. You know, when we were at when we did go to the, I'll call it the Mr. Ferguson referred to it as the meeting at the side of the road. It was basically one of a few public information centers that were held to meet with in advance. You know, in order to be able to facilitate, you know, an informed conversation, you know, we did have to take it to such a point where we could speak to the proposed works and the proposed costs more than what was discussed at the earlier meeting, where, you know, it was a very high level, you know, estimation. So, you know, that much is the case. We did talk about the options at that time, you know, how to proceed and go forward. The next point is that, you know, as I mentioned earlier, it was one of the points I wanted to make sure I reiterate is that the assessments of the branch drain do not correlate with the assessments of the main drain, and so we can't tie the two together. I did earlier just speak to my comparisons to the main drain, the works that were last done in 97, and how my proposed assessments for that landowner compare quite closely. You know, it is a difficult situation because, you know, again, it's a matter of this water is causing an erosion to Mr. Miller's property, and it is causing a concern to his home. And Mr. Miller is not contributing the water, any of his water to the Dell drain. So that erosion issue, that concern that has been raised, you know, that is being generated from the flow from those upstream properties. And as for why the drain didn't go further in 1997, that would be speculation, and I haven't seen anything in the report or otherwise that speaks to it. I think it's easy for us now in hindsight, some, you know, 20 plus years later, to look back and think, well, maybe they could have done it at that time. You know, perhaps they didn't appreciate the concerns that we have as we know them now.
Thank you. Do we have more people with comments? Aaron?
Seeing none.
Go ahead. Hi, it's Roger Somerville.
Go ahead, Roger.
Okay. My concerns was I'm hooked on to it through the G branch of the drain back when they decided that that's the way that the water needed to do, because to go because that solved all of my problems. If I could get it to that outlet, that I would have no more problems. And I did not have a choice at that time because Central Algon took 51% of it. So it was just coming and telling me what was going to happen. So they forced that onto me. Now they're willingly to put the expense of at least that much or more because I did hook onto the Dell drain. And the results of that, they were taking 51% of the cost, but now when it comes to the length of the roads that they're hooking onto it, and they don't want to take like more of a benefit. And if it wasn't for the drain going down through there, if that road goes out, I would think the benefit to Central Algon would be pretty great in the results of that. And as to say, no water from Mr. Miller's property is going to the drain. I think you need to look at the hillside, the gully, the water seeping out of the bank, running down the side of that bank to the drain, which goes to the lake. So I would say Mr. Miller has an outlet of water coming out of the ground that's going to that in that drain by just looking at the weeping, which is causing all the problem, which is supposed to be our problem because we have a drain down through the bottom of it, which the drain, the bank is seeping down through. So I would say there's water from his property going down into our drain. I don't know how you say there's no water. So that's why I feel Central Algon and Miller should be paying more on this assessment. That's all I have to say. Thanks.
Thank you, Roger. Mr. Hernandez, would you like to comment on that?
Certainly, thank you. So just to clarify that most recent point, when I was saying that Mr. Miller's water does not flow through the Dell drain, I was referring to the piped section and also the proposed pipe extension that is referred to in this report. I do agree that Mr. Miller has runoff of other kinds. That's clearly noted in my report that his runoff does not use that pipe. So the rain and any kind of groundwater and so on, that's certainly still present. This report is not intended to address that. But when we met in the meeting to consider previously, we had the senior geotechnical consultant attend, who confirmed that the erosion is a significant risk to Mr. Miller's property, and we talked about those technical details quite extensively. So that's why Mr. Miller's water is not going through the pipe. That's why he's not being assessed an outlet, only the benefit assessment, unlike the upstream landowners, which are outlet assessments, which are essentially based on the volume of flow that are coming from their respective properties. With respect to branch G, I'll make a couple points about that, but then I may have to defer to Mr. Brooks, as I wasn't a part of the branch G project. But I do understand that it was the decision of a tribunal that ultimately resulted in the branch G being connected to the Dell drain. I did have a chance to speak with Mr. Miller on multiple occasions about it directly. And Mr. Miller, and I don't know if he's on here or not, but he had told me that, he already had a concern. And I think that, the fact that the branch G was connected maybe just, heightened his concern, but he was already concerned to begin with. What was I going to say? And then with respect, the next point was with respect to assessments to Central Algon, I wanted to clarify that the municipality is assessed. It does have an outlet liability assessment. It is noted on page 20 of 31 at the top. So there is two assessments of, a $14,000 and an $8,000 approximately assessments for water that are generated from the roadways. So that is being done. Those are outlet assessments based on amount of water generated from those roadways. They don't have a benefit assessment. The municipality does not have a benefit assessment in the way that was assessed in the 97 report, because the work done in the 97 report reestablished the roadway, whereas without it, obviously it would have been impassable. This does not affect the passability of the road, and so that's why there's not that same approach taken here. Yeah, I think I've covered all those issues. Thank you.
Mr. Hernandez, I believe I heard someone suggested that Central Elgin's share of water from the road is low. Can you respond to that?
Sure, thank you. Yeah, so without getting into too much detail, the way in which we assess the amount of water from any given property, whether it be a roadway or a residential property or an agricultural property, is based on assessment of the of the use. So it's the volume and rate of flow expected to come from those properties. And so the more impervious a surface that there is on a property, the higher the assessment is. So if you look at, for example, an assessment for a roadway, and you look at it on a per area basis, and then you compare it to an agricultural property on a per area basis, you'll see that the roadway is higher. So we always make sure to reflect that it's not, all properties are not apples to apples, and we do take measures to reflect that in the assessment.
Thank you for that. For the benefit of our quarter of revision, I wanted to clarify that because you're the expert, and I need to hear that, in your opinion, that number is fair.
Yes, sir, I believe it is.
Mr. Perrin, is anyone else wishing to speak?
Mr. Chair, Walter.
Good evening, Walter. You have the floor. Go ahead. I believe you're on mute.
Yeah, it's Walter Hayhoe, and I'm here with Gary Somerville. And in my estimation and in my letter to the council, I'm concerned about the extension of the drain beyond what it was finished out at in 1997. So there's two reports. We've got the Dell Drain report of 1997, and we have the Dell Drain outlet report of November 26, 2020. Someone or the engineers have added extra lineage to that drain across Mr. Miller's land, which is receiving the most benefit for that extension and the control of the water out and beyond what we had bought and paid for in 1997. So without landowners' contributions, the engineers have introduced a further extension and enlargement of the drain, and primarily to Mr. Miller's benefit. And he's not, I believe he should be paying more, and perhaps because of the extra land that Branch G has introduced, without any consultation to the main farmers on the entire Dell Drain as constructed and repaired in 1997, that we were not consulted as when Branch G was introduced into that outlet silo on the south side of Barnum's Gully line.
So I am flabbergasted that we have to pay so much for such a specific benefit that serves one or two properties. And I think that the benefit should be rearranged to reflect who's getting the benefit. Now, I also have Gary Somerville here on my, and perhaps do you want to accept his comments here now, or?
I'm going to give Mr. Hernandez a chance to give a rebuttal to your comments, and then we'll certainly get back to Gary. Mark, do you want to comment on what Walter has said? Please.
Thank you very much. Yeah. So again, I would come back to the fact that the water coming through this through the piped drain, the pipe dell drain, and this proposed extension of that drain is not from Mr. Miller's property. So in other words, the water that's coming through that pipe from the upstream lands are causing erosion and concern, like erosion, loss of physical property, as well as Mr. Miller's concerns about his residence. And so, it's, if I may try to think of, other analogies where one landowner is causing damages or loss of another landowner's property, but then expects that person affected to pay into it. Drainage is one of the few that I can think of where that applies. In most other cases, it would be the person causing the damage that would pay in full. So, we have followed, in my opinion, I think the proper procedure where Mr. Miller has received a benefit assessment. It's certainly not zero. It's consistent with what has been established in the past. And we think that the approach taken has been reasonable. I think it would be challenging to think that Mr. Miller should be paying, a substantial portion, let's say, half the cost to protect his property from water that is being generated from other properties. With respect to the branch drain, I thought perhaps either Mr. Waterman or Mr. Brooks might want to speak to that, because again, that was a separate appointment and it was a tribunal decision, to my understanding, that resulted in the connection the way it did.
Jeff or Sean, would you like to comment on that?
Sure, I can comment on the branch G. So the branch G of the Dell drain was a different situation than what we're facing here. The municipality petitioned for drainage as part of the branch G to create the branch G drain. We had a landowner whose water was crossing a cross culvert that the municipality owned and spilling out onto his land, creating damage to his land. So the municipality reacted to that complaint, and we ended up with the branch G of the Dell drain. So branch G of the Dell drain collects water west of the Dell drain outlet and is conveyed down the roadway, and all the water from the roadside ditches ends up in through branch G and into the Dell drain outlet. So when we're comparing what the municipality paid on the branch G drain compared to the Dell drain outlet, we're kind of comparing apples to oranges, and it's really not a fair comparison. And I would like to say that as a staff member of the municipality, we're very cautious when it comes to dealing and commenting on the engineer's assessment, as to be fair to all the landowners in the watershed. So we don't want to be seen as trying to sway assessments one way or the other. We really rely on the knowledge and expertise of the drainage engineer.
Thank you, Jeff. Walter, would you like to ask questions of Jeff or Mark?
I'm going to open it up for Gary's here in the room, and let him, Gary Somerville, and let him have his say.
Go ahead, Gary.
Okay, some of the concern I've kind of had, back to this branch G thing again, some of the landowners, in fact, pretty well all the landowners north of Barnum's Gully line were not notified at all when that situation was done. And that is the main point. That extra water is what's seemed to have excited Mr. Miller, because he was concerned that there was going to be more erosion. But in that report also that I have, which is wrote on October 30th, 2015, it said it's in this report when the G branch was added, and that according to engineers Matt DeWitt and Henry Hutori, I believe, and Mr. Jeff Brooks, stated there should be no impact erosion due to the timing of the water passing through the C branch of that drain. Well, we're saying two different things here. He's concerned that there's a lot extra water added and there's going to be erosion, and those three people from your side is saying there should be no extra because of the design of the drain. Another thing that concerns me is that this thing was started 5 years ago. It seems like we're a long ways behind on the thing. I'm sure the erosion, if there's as bad as everybody says, is really increased a lot to what it should have been if it's as bad as everybody talks about. And also, we're not even working, I don't think, with actually realistic numbers here, because to my understanding, that was an estimate only, the numbers we have here, and not an actual quote of the job. And it was also back in 2018. So I would be surprised if we're not dealing with numbers that are a fair amount higher than what is wrote on this this report here.
It certainly probably cost hasn't gone down, that's for sure.
Yes, no, I'm quite sure it would be higher. I don't know if Mr. Brooks would have any idea from other projects if, you know, is this thing, just my understanding is if it goes over 133% of this, the numbers we see here, what happens then?
Through you, Mr. Chair. I'll let Mark comment on the estimate that was provided in the report here. I can let the Court of Revision know that there is a threshold if the once this drain is passed and we get to the point of tendering this project out, if the actual costs come in, as Mr. Somerville said, at I believe it's 133% over the estimated cost, we would require another meeting of council to approve that that new price, and that would provide, I believe it would provide landowners another opportunity to voice their opinions on the construction cost. But Mark can correct me if I'm wrong on that one.
No, you're correct. It is 133%. If the tender price is over 133%, the DAC does require everyone to circle back with the landowners and have a discussion about how to proceed from that point. So there is that protection. You know, the numbers are, you know, are considered, the estimate is considered to be current. You know, we have done our best to reflect the nature of the site in the estimates, because if you've seen it, it is difficult to access to the point where, you know, we had a constructability discussion with a contractor at the outset to make sure that you know, construction was viable before we even, you know, really got started with the project. And of course, at that time, they confirmed that it was. So we've taken, you know, costing from suppliers, from past projects, and worked to reflect the nature of the site, the steep banks, and so on in the pricing to make it as close an estimate as possible. There are always market forces on equipment and materials and so on that are at play, and I believe that's why the 133% is in the act to protect against something that you know, could be higher than is expected. With respect to the comment about how long it took, I really want to emphasize that you know, painstaking measures were taken by all parties. You know, both myself, Dylan staff, and administration with the municipality to make sure that what we were doing was going to both address the concern and be as efficient as possible. We initially were looking at a longer extension. We curtailed that based on the advice of the senior geotechnical engineer. Options were reviewed about not doing this work, and could Mr. Miller's home be relocated? I mean, every reasonable option, I think, was given due consideration, and yes, so it did take some time. There are some technical, complicated technical matters involved too, which I won't bore everybody with, but that's why it took the time it did. And then my last comment with respect to the timing of the flows, although I wasn't party to the discussion, I know that I can clarify that Branch G is connected very close to the outlet, as Mr. Brooks said. It's right near the roadway, and so the water will get through Branch G and out through the Dell drain, in all likelihood quicker than water flow that is coming from much further upstream. And so the water coming through Branch G will enter and be released from the Dell drain sooner before other water can get there. So it's really, the conversation is really about peak flows, but the total volume will increase because you've increased the drainage area, that is for certain, but the peak flows may not increase as a result of the location of the Branch G drain.
Thank you. Mr. Perrin, are there any more landowners wishing to speak?
Go ahead, Mr. McNamee.
Okay, I put in writing, Mr. Chairman, I'm Phil McNamee, the president of Phil McNamee Charitable Foundation, which owns Solitude Nature Reserve. And I put in writing our thoughts of why we feel our assessment is too high. As you know, by our thoughts is we do not charge the general public, including citizens of Central Elgin and Elgin County, for use of our nature reserve. But I do have a couple of questions of the engineer. He mentioned about they take into account the volume and rate of flow of the water on lands when they determine the assessment. Given that our 24 or 25 acres that are in this watershed of the Dell drain is actually a holding area for water because we don't drain it off. We want wetlands. We've built boardwalks over the wetlands to encourage wildlife. Shouldn't we be getting a credit for this by holding the water back instead of being assessed to increase the water flow? So I'm a bit puzzled with that. Also, in response to a question by another landowner about the flow of water, not only is coming from the Dell drain, but it is coming from the bank itself. And the engineer stated that the water that was causing the erosion at the Dell drain was 100% from the Dell drain. But in my understanding, I'm not an engineer, but if I got water coming over top of a bank, has to be some of that water going into where the Dell drain comes out. It's not possible that water is going to be diverted away from the outlet of the Dell drain. So has the engineer looked? Although the water doesn't drain into the Dell drain, it will drain into where the outlet of the Dell drain is. And how much water is coming from the Dell drain outlet and how much is coming from the bank of the landowner? I think that's a very important question that needs to be answered. Thank you.
Thank you. Can you answer that, Mark, please?
Yes, thank you. So I'll start with the first comment with respect to the flow from the property. As I mentioned earlier, we do take into consideration the nature of the property when we talked about a road versus residential property versus an agricultural property. We also look at lots such as this one, and we have given it a reduced rate to reflect the use of that property and the anticipation that there is less flow coming off it. To expect that the property will never use the Dell drain, I think is not something that we can support. And typically when you have lands in the watershed, that's not the process. But what we did do is we identified a reduced rate. And so the cost has been reduced accordingly. When you look at the actual schedule of assessment, you'll notice a little asterisk by the property with a subnote that talks about that clearly identifies in the assessment that it is a reduced rate of flow and that the cost is reduced as well. So that was the first point. The second point, again, about the flow from the bank, I want to make sure that we clarify when I'm speaking about the flow through the Dell drain. I'm referring to the piped sections. So the existing pipe section and the proposed pipe extension. Mr. Miller's water will not flow through those pipes. Again, I agree that there are other flows, whether it's over land or groundwater or what have you, naturally occurring, and certainly that's noted in the report, and it was discussed extensively in the meeting to consider. So this is not, this is not a panacea. This is not a silver bullet, but it is addressing a primary concern that has been raised by the landowner. And the extension is intended to address that specific concern.
Thank you, Mr. Hernandez. Do we have any more landowners, Mr. Perrin?
No further, sorry, Walter.
Go ahead, Walter. Go ahead.
Muted.
You're muted, Walter.
How about now?
Perfect.
Okay, it's Gary Somerville, sorry.
Okay, Gary.
Yes, I have another question here. Back in 95, the Dell drain ended at Barnum's Gully line. The municipality, as the road went out there, the municipality approached the landowners upstream on the Dell drain to come and see if they would help them out to repair the road and get it open and I guess repair that gully or whatever, when you talk about the assessment from the landowners. But if we had not agreed to help the municipality out at that stage, to my understanding, that water's ran there, I know, all my lifetime. Is that not deemed like a natural water course? Would we still be in this same predicament? Would we be assessed on these at these rates that we are now, or? And if not, then that's another reason I feel the municipality should step up, because we stepped up to help them at that point, repair the road. But what would have happened there if we had not gone in with the municipality to extend that municipal drain?
Can you answer that, Mark? Can you answer that, Mark, please?
I'm sorry, I can't speak to what agreements were made in 1995. I'm not sure.
How about you, Jeff?
Okay, Mr. Chair, I'll try and speak to this one. I wasn't around in 95 or 97 when the first extension was put in, but my understanding was that there was a petition granted under Section 4 of the Drainage Act, which regardless of agreements or not would assess costs upstream similar to what we're doing now. So I don't believe that there would be any difference regardless if there was an extension put in 95 as opposed to what we're doing here now. It's all the assessments are made as per the Drainage Act, as I believe they were back in 95 and 97 when this first extension was put in. So it really has no effect on how the drain is assessed.
Thank you, Mr. Brooks. I'm going to ask if there's any members of the Court of Revision with questions. I just first want to be satisfied that the landowners have had their voice. No further questions.
Seeing none at this point, Mr. Chair.
All right. Counselor Fair, comment?
I'm just curious, this is to Mark. I know you talk about the water flowing in the pipe. How can the water flowing in the pipe cause the erosion, or is the erosion coming from the surface water and the bank is going to collapse anyway on Mr. Miller's property?
Thank you for the question. So, you know, I've been down right at the outlet personally on a couple different occasions, and what you'll see is if you refer to the drawings, the 1997 drawings, you'll see a steel pipe outlet and a concrete mat. When you go out today, what you'll see is the steel pipe outlet, the concrete mat, and then at the end of the mat is basically a vertical drop down. So as soon as the, you know, those hard surfaces, if you will, end, then the erosion starts immediately. And from that point, we get into the, you know, technical discussion we had at the last meeting with our geotechnical engineer, speaking about the erosion destabilizing the toe of the bank, and how that, when you project that back, it you know, it threatens Mr. Miller's property. You know, we spoke about how, you know, there are still some very steep banks out there that, you know, may come down no matter what, but this is about protecting the property from the long-term impacts of the erosion and the destabilization at the toe of the bank.
Are there any further questions from the Court of Revision? At this point, I think everyone has been given a fair opportunity to be heard.
Mr. Chair, there's another question from the gallery.
Okay, go ahead.
Go ahead, Mr. McNamee.
It's Phil McNamee again. In all due respect, I don't think I got my second question answered by the engineer. He didn't let me know, or let anyone know, the amount of water that's flowing from the top of the bank that's ending up in the, I know it's not going into the Dell drain, but it has to be, some of it has to be going into where the erosion is being caused, where the Dell drain is. So that water from the bank is also causing an erosion problem where that outlet is. But the landowner is not being assessed anything for any benefit of the actual Dell drain improvements. He gets a beneficial interest, but he's got water going into that outlet as well. There's no way that that water is staying away from where the Dell drain comes out. It has to be flowing down the bank towards that thing.
That's what's
And
causing
that
erosion that bothers his property. And the lake bank keeps.
Mark, would you try to answer that question, please?
Yes, thank you. So again, I agree, and I've acknowledged, and it is written in the report, that there are other forms of erosion that are taking place, whether it be wind or rain or groundwater, what have you, and this will not address those. So to some extent, Mr. Miller will still have some erosion that takes place on his property. I acknowledge that. The senior geotechnical engineer has acknowledged that as well. Again, this is to address the erosion, the primary concern of the erosion being caused by the flow coming out of the pipe. To try and give numbers to, you know, what is coming over, you know, down the hill, either through seepage or overland flow or what have you, I think is it's not realistic. It would be, we could never be accurate about that. But what I can say is, you know, Mr. Miller's property, you know, is quite small, like a very, very small fraction when compared to the larger watershed. So we have, you know, a large upstream watershed, which all of the flow coming off of those properties is being concentrated and discharged through Mr. Miller's property. So it is going to be far and away a much greater volume than is anything that would be generated off of Mr. Miller's property.
Thank you. All right, I think Everyone again has been given a fair warning, fair opportunity to be heard.
Yeah, I have one more, Mr. Chair.
All right. Go ahead, please.
Yet, sorry, Mr. Chair here. Just as we listen and go through some of the comments here, Mr. Hernandez keeps referring to the senior technical man that was part of this process. The last quarter revisions municipal Zoom meeting we were on, that man admitted that he'd never been down to the bottom to see the outlet. A bit like we're talking about the seepage. To me, there's a deeper question here than what we're talking about on this percentages, that in the future, when we're doing municipal drainage work and the engineer comes and tells you that his cost before any work is done is 80 to 90% of the cost, I think the township really needs to assess how you do future drainage work with this company, and they tell you at the first side of the road meeting that these costs are this high already. I really think, you know, that this whole assessment is good, but we keep referring back to Mr. Hernandez, but he told us on the side of the road he was already 80 or 90% of the cost on the first meeting. It's all about everything he tells us we're supposed to believe, the 10%. When we look at many other drains that we've been part of, how that benefit can vary from 30 to 50%. I think the township really needs to look at whether you have 1, 2, 3 engineering companies do a brief overview on each job and an assessment and cost, so landowners are satisfied and that it's been well thought out, because it seems like this we've been involved in many municipal drains, and to be at these kind of crossroads at this late moment, you need to look at your business plan, how you're doing that, because it's not working at this point.
Your concerns have been noted. Before I wrap this up, I think, and I'd ask Mr. Brooks to correct me if I'm wrong, our job here tonight is to give everyone a chance to be heard. I think we have. We rely on expert advice from Mr. Hernandez, and that's what I think we have to base our decisions on. I certainly can sympathize. I understand a lot of the opinions, but you know, I'm going to wrap this up, and we'll have a vote here and decide where we're going. I'm only one member, but if you wish to receive notice of the decision respecting the Dell Drain outlet, please email the Secretary Treasurer Diane Wilson, Deputy Clerk at dwilson@centralalgon.org, or call her number at 519-631-4860, extension 286, and provide your name and mailing address. This time I'd ask the Court of Revision if you're willing to make a decision. Councilor Kravitz.
I'd just like to comment on something. This whole, I had a lot of problems with this Dell drain, and where we're sitting at now. Back in the day, we used to have barn raisings. The community would get together and put up a barn so it could house livestock to help the community. It would be full circle. The Drainage Act is a 160-year-old act. It's one of the oldest laws in Ontario. And initially it was set up because most of the dry land was taken by residential and the easy farms. So it gave the municipalities power to create a drainage system, to drain property, to create more farmland, to better the community. What's happening nowadays is the Drainage Act is not being used as for drainage. It's being used for personal gain. And the only person that applied to this drain here was Mr. Miller. And he's doing it to maintain his property at the cost of everybody else. And Mr. Hernandez, you even mentioned once that for maintaining value is a reason for this. Well, what the property owner is, he's maintaining his value. It's not going to last forever. The lake bank's there has to be some onus on buyer beware on this. We're stepping outside of the realm of the Drainage Act, but in this instance, I think that there should be something, a larger assessment on somebody taking their own responsibility for property they have. that's just the point. So leaving this the way it is, I don't feel comfortable leaving this the way it is. I know we're going against an engineer's report. I respect the engineers that have done their homework, but for the due diligence for the property owner, buying a property and then the first thing you do, you go out and you throw your flag up, I want maintenance on this municipal drain. Well, is property bought with the aspect knowing there's a municipal drain at the property? And it's a very expensive project for a lot of people. We had 22 people on this report, and at our last meeting, 20 of the 22 people were opposing this drain. And the main reason was the financial implications. Some of these going through here, some of these are 46,000, 22,000, 6,000. This is money out of people's pockets, 32,000, 10,000, 44,000, 23,000, 20,000. It's a huge payment, and we're not improving the drain. We're not making the land better to grow on. It's not doing the job of the Drainage Act, the initial intent of the Drainage Act. We do need to get a legal outlet, and back in 97, when the drain was rebuilt, perhaps there was an error done back then. So I think I would be more than comfortable to change this at this committee or this quarter revisions, the amounts, but I don't think we should put a number. It should be a percentage. Because as was mentioned earlier, this is a 4-year-old, 5-year-old report, and I'm sure the number's not going to come in at the 380,000. It's going to be in the 500 range. So I don't know if we have discussion on that at this point or what people feel.
If I can make one comment, and I agree with everything you said. I remember the day the late Bill Martin told me that you could fill a hockey arena with people who do not like the Drainage Act. But the rules are, like you said, 160 years old, set in stone. You're either going to win or lose on them. But I will point out, if we change this, the percentage of the cost, take it away from someone, it has to go on someone else. So the cost of the project remains the same. So I'm just chairing this meeting, but if we have to go, if this goes to an appeal, we're going to be asked, why did we do this? We better have a logical reason. Because if we say that we think, that's just an opinion, and we've hired Mr. Hernandez as an expert. I'm only pointing that out. I'm not disagreeing with any of the comments, but we have a responsibility. Councillor Fair.
I'd just like to ask one question in regards to what Councillor Kravitz has said. Miller is protecting his property. Isn't there any benefit to him protecting his property? He's the only one getting the benefit out of this by prolonging the eventual erosion of his property down into a gully or whatever, but he's the only one that's actually getting a benefit of this change. Is there no assessment on that?
Mr. Hernandez, would you like to reply to that?
So yes, thank you. I just wanted to clarify that Mr. Miller is, based on the current assessment, he is subject to a benefit assessment of $25,000. So I do want to clarify that it's not a case where Mr. Miller is not getting any assessment. He is, and it's currently $25,000 based on the current estimated total cost of the project. Just, if I may, one of the things I wanted to clarify, because I didn't want to let it linger, there was a comment earlier that we waited until there was 80 to 90% of the total costs incurred prior to coming forward to the landowners, and that is absolutely not true. And I don't want to leave council with that kind of an impression. That is absolutely categorically incorrect. And I just wanted to clarify that for the record. Thank you.
All right, I think it's decision time now. If we make a decision here based on the expert advice that we've hired to give us opinions for Central Alberta's benefit, we make a decision based on that. If we disagree with it, this will likely end up into another appeal, and we'll need to justify any adjustments we make. That's all I'm going to say. And if there's no further discussion, I think it's probably time to call the vote. Go ahead.
At the start of the meeting, Mr. Brooks said we were here to decide if somebody was too high or too low, or there was due consideration given. And I still believe that the benefit, I don't know, maybe Mr. Hernandez, you can answer this, but in your report, I believe it's a special benefit. What is a special benefit column in the chart? And the 25,000 benefit, how is that arrived at? I'd like to know some thought process on how that 25,000 number is when was stated earlier, the G branch, when it was put through, the municipality applied for it and ended up carrying 51% of the cost. Why isn't the landowner who applied for it carrying 51% of the cost? Go ahead.
Thank you for the question. So again, we can't relate the assessment for a branch drain to what is happening on the main drain, on the main dull drain. The reasons of why those costs were apportioned the way they are, I can't speak to because I wasn't part of it, but I do know that they are not, branch drain assessments are not directly relatable to assessments for the main drain. As I think I mentioned earlier, if we use the example of the assessment for the 97 report where it was on the main drain, the municipality carried a large a portion of the cost on that one, but that was also because the road had failed and it was a matter of reinstating passage along the roadway, and so the amount was higher accordingly. With respect to the special benefit, Mr. Miller is not receiving a special benefit. That is not being applied here. It is just a very simple benefit assessment. And it is intended to be a nominal amount, recognizing that he does get to maintain the value of his property, and that it is consistent with with what had been established in the 97 report.
Okay, I just like to be on record of saying, personally, it's our quarter revision is a group of 5 people. We can vote on how we feel. Using the Drainage Act as a tool to, he's bettering his own property. And I think there should be a higher assessment on the Millers for that is the way that I'm going to be proceeding with this, but we can vote on how we would. Thank you.
Madam Deputy Clerk, do you have a resolution?
I do, Your Worship, or sorry, Mr. Chair, I don't have a mover or seconder for the motion.
Could you read the motion, and then we'll see if we can get a mover and seconder, please.
The draft motion reads that the Court of Revision agrees to uphold the assessment schedule for the Dell Drain outlet as per the report prepared by Mark Hernandez, Engineer Dillon Consulting, and further that if dissatisfied with the decision of the Court of Revision, which was pronounced on the 22nd day of March 2021, anyone may appeal this decision to the Agriculture, Food, and Rural Affairs Tribunal by filing a notice of appeal with the clerk of the municipality within 21 days of the date of this decision.
Do we have a mover and seconder for that motion? I think that last line spelled out the options for our landowners. There is another appeal, and I can't foresee the future, but this may depend on our decision. I think it could be appealed either way, but I think we need to make a decision. Need a mover and seconder, please.
Not putting up my hand to move. I'm just putting up my hand to say that Councillor Kravitz has brought forward some very good points. And
there's certainly a lot of emotion here, but it's been pointed out to me, if it goes to appeal, we'll be called in to justify why we change this. Because we're emotional, or we think it's too high, they're going to laugh at us. I'm only saying that as fact. Believe me, I don't like this any more than anybody else, but we have a job to do.
I'd like to ask a question.
Go ahead.
This is directed to Mr. Shipway. What happens if the motion dies on the floor?
To you, Mr. Chair, the Court of Revision does have to provide some direction on how to proceed on this because this is appealable. So the Court of Revision needs to provide direction on how it would like to proceed.
Make the motion. Moved by Councillor Fair. These landowners will still have another appeal.
I will second.
Councillor Wynn seconds this motion. Please call the vote.
Counselor Cook,
Yes.
Counselor Cravitz,
No.
Counselor Fair,
Yes.
Counselor Wynn,
Yes.
Deputy Mayor Marks.
Yes.
Carries.
Yes. Motion passes. And we're at the point of adjournment, so I thank everyone for your attention tonight. We didn't make everyone happy, and that's probably not our job, but I think we did our job, so thank you everyone for your attention, and I will adjourn the meeting